about that as well, but I want to welcome right now into our conversation as well Jennifer Mascott, a law professor at George Mason University. Jennifer also served as a law clerk to both Supreme Court Justice Clarence Thomas and to then Judge Brett Kavanaugh. Thank you very much for joining me on this. Give me your initial take on this ruling today, overturning affirmative action. Was it something you expected? Did you see it coming down the pike?
Well, thank you so much for having me. Today, a 6-justice majority found that it is not constitutional to discriminate in university admissions on the basis of race, and that universities cannot consider race as an independent, separate factor. But the court does say at the very end of the opinion that race can be, if it has impacted another aspect of your background or circumstance, that an applicant can discuss and university consider race as it would any other factor. It just can't be used as an independent basis. And I think one thing here that probably really swayed a lot of the justices and that they took into a lot of consideration is that the application programs they were looking at, in particular, they thought, according to the Chief Justice today, had some stereotypes about certain racial groups, such as Asian Americans. And so perhaps similar to some of the discrimination in the early 20th century Jewish Americans faced, I think the court felt that there were some stereotypes actually disfavoring particular races. And so the court is saying that one race can't be preferenced or put beneath another just on that basis. The whole person needs to be looked at. Interestingly, the court here, different from the big blockbuster constitutional decisions last year, did not squarely overrule precedent. It said that even under its past precedent, that these university programs could not be upheld. And perhaps that's why the Chief Justice today here was writing in a majority for 6 justices, in contrast to the decision on Roe versus Wade last year, which had only a 5-justice group joining in the reasoning of Justice Alito's opinion.
Jennifer, let me ask you, you're probably familiar with the country's attitude towards affirmative action and the fact that the majority of this country wanted to keep affirmative action in place. I realize it is not up to the justices to necessarily look at polls when they're writing their decisions and analyzing the way they're going to think. But should the Supreme Court now expect, fairly so, a lot of blowback 2 years in a row now, defying the vast majority of Americans in their rulings?
Well, even the ruling that a lot of folks adhere to today, the Grutter ruling from about 20 years ago, said that hopefully there would be an endpoint and a point at which we would, continue to progress and not have to give such a categorical look or consideration to one factor in comparison to others.
Jennifer,
and so I think the court here sees.
Let me interrupt you in that. I agree. That was the hope of Justice Sandra Day O'Connor back in 2003, that would happen. It was theoretical. It was aspirational. It was not necessarily something that would come to pass guaranteed, and it has not. So when you say that the hope is, that's fine, but law is not based on hope. So where does this go?
Well, again, I think a really telling thing here, and this litigation was in courts for 10 years. In fact, one of the original attorneys, sadly, who worked on this litigation passed away earlier this year from brain cancer, tragically, at a fairly early age. But I think it was really looking at the particular metrics and specifics here of how Asian Americans in particular are disfavored here. And so the court is saying there can't be a particular group on the basis of race in this country that admissions folks are discriminating against.
And that is specifically, just so everybody knows, that's specifically to the Harvard case. That was not necessarily stated in the University of North Carolina case, just to make sure everybody knows with which case we are dealing on the Asian American situation.
And then the court, I think, towards the end of this opinion today, which addressed both programs, said that, like other factors, surely if an applicant has been impacted by race, which I think would encompass some of the circumstances that Reverend Sharpton was talking about, that can certainly be mentioned, and that admissions folks certainly can look at that. But as they would at any other factor of somebody's background, like socioeconomic status, perhaps illness of a parent, all of these things that cause terrible hardship and challenges, can be looked at tied to a person's whole application and character. It's just not looking at one factor that's a constitutional violation in isolation, is what the court's opinion today, I think, is saying. So I actually think it's too broad to say that race cannot be considered. I think the court is saying it can be considered along with all of the other circumstances that might have impacted somebody's personal background in an application, just not given particular individualized weight. You can't consider race as race in admissions in a categorical way any longer after these opinions.
Okay. Jennifer Mascott from George Mason University, thank you so much for jumping in and getting in front of a camera and joining us. I appreciate your time and your insights. Let me go back to my panel, and I'll pose the first question.